My Lords, I beg leave to introduce the Amendment 52F, which is in my name, but before doing that I'd like to endorse everything that my noble friend Lord Carlisle has just said and recognise that there are countries that people should not be sent to where convention rights would not then apply if there was subsequent reform. Can I also agree with the opening remarks made by the noble Baroness Lady Hamwee in moving her amendments, and again I'd like to endorse those and associate myself with those remarks. Lady Hamwee was one of those who attended a meeting which I organised here before the second reading of the bill, where we had the Salvation Army and a number of other stakeholders who attended. The noble Lord Coker was also present at that meeting. And the point about the Salvation Army is particularly relevant because, of course, they are one of the stakeholders who work for the Home Office in dealing with many of the people whom we are discussing in the context of this bill. And arising out of that discussion, I thought it would be good to table amendments along these lines. In fact, there are others elsewhere in Group 19. I'll come back to that in a moment. But in this group, Group 4, Amendment 52F, would ensure that there is consultation with relevant stakeholders in the country to ensure compliance with international obligations, and detailed assessments are made in respect of protection and support. I remain concerned that the bill does deny access to protection, safety and support for those seeking refuge and victims of modern slavery. I touched on that earlier in earlier groups that we debated this afternoon. In doing so, far from breaking the business model of people smuggling, as the government repeatedly state, instead of that, in deterring illegal entry into the UK, I think it merely enhances the ability of people smugglers and people traffickers to operate with impunity. Currently, there's been very little assessment of the implications of the bill for those seeking refuge and victims of modern slavery, including compliance with international legal instruments, as well as the financial implications if implemented in the wider modern slavery strategy. And I know the House is waiting with anticipation for the findings of the Joint Select Committee on Human Rights, which will be meeting again tomorrow to hopefully come to a final conclusion about the report that it's had to rush pell-mell, one might say, because of the pace at which this bill has been taken through both houses of Parliament. But nevertheless, that report, hopefully, it will be a unanimous report, but if not a majority report, will be available to your Lordships for further consideration at committee and report stage. I think, my Lords, that this bill could have potentially devastating effects on the rights of survivors of modern slavery, and furthermore, it's clear that my concern is shared right across party divides. We've seen that in the context of the debates in another place and the speeches made by people like Sir Ian Duncan-Smith and Theresa May. They've been quoted in our earlier debates, but also from the survivors of modern slavery themselves. And indeed, the Joint Select Committee on Human Rights has had evidence from people who have been victims, and I personally found it very moving to hear some of their own accounts. But we've also heard from former law enforcement officials, from lawyers, and people who have dealt with these issues over very many years. Now, rather than repeating what's already been said, I want to speak specifically to 52F, which will ensure that there is consultation with relevant stakeholders in the country to ensure compliance with our international obligations, and that detailed assessments are made in respect of protection and support. The amendment, as I've said, sits alongside 85C and 92B, which are also tabled in my name but don't come until much later in Group 19. But they would put onto the face of the bill an obligation for the government to carry out due diligence to ensure the safety of those who are removed from the UK to other territories and countries, and indeed we'll come on to that question as well in another later group of amendments. These amendments have been drafted with survivors of modern slavery and human trafficking in mind, as they too will be subject to removal from the UK if they've been deemed to enter the country irregularly. We know from experience the time it can take for a survivor to feel safe and begin their journey of recovery. We all know how heightened vulnerabilities need to be protected against trauma, and the kinds of experiences which have been referred to in some of our earlier debates, the experiences that people have to endure. I cited one example earlier on, reported to me by the Children's Commission. I'm still shocked about the story of a young boy from Iran who watched his parents being executed. It took him a year to get to the safety of this country. And the idea that he could be returned to who knows where or when is just unconscionable as far as I'm concerned, and I think as far as probably most members of your Lordship's House are concerned. And that is why we have to think very carefully about the protections that we place inside this legislation. We also know, my lords, that removal of survivors to another country against their will can exacerbate their vulnerabilities, or indeed the fear that they might even be repatriated, the worries of delay, or the prevention that the recovery process can unfortunately lead to in an individual being re-exploited or re-trafficked, doing nothing therefore, as I've suggested, to break the wicked cycle of exploitation. If the government insists on pushing forward with these plans of removing trafficking and modern slavery survivors from the UK, it must do so with the utmost diligence and transparency. And that's why Amendment 52F will require the government to undertake comprehensive assessments, including detailed consultation with relevant safeguarding and support organisations in the country or the territory to which the survivor may be removed. It would also require the government to assess the human rights situation of the relevant country, the protection and support available to potential and identified victims, the risks of further harm by exploitation, trafficking, and the risk of direct and indirect refoulement in that country. The amendment would also require the government to confirm whether the duty in Section 2 and the powers in Section 3 would not contravene both national and international legal instruments, including but not limited to the Equality Act, the European Convention Against Trafficking, which I referred to in an earlier group of amendments, the Refugee Convention and the UN Convention on the Rights of the Child, which we discussed at length in an earlier group. Many of us in this House and in the other place will continue to work to ensure and enshrine the rights of survivors of modern slavery. Amendment 52F, alongside 85C and 92B, when we get to them, are there to ensure some level of transparency and due diligence, which has so far been lacking within this process. The removal of survivors from protection in this country risks fueling the cycle of exploitation that consumes lives and spits out profits for ruthless criminals. It's for this reason these amendments have been tabled, to ensure the bare minimum is done to ensure the safety of those who are at risk of further harm of traffickers. In summary, my lords, 4 points. 1, the amendment's primarily about ensuring that if there is intention to remove people to specific countries, there is a detailed understanding of both the risks and also legislation, policy and practical resources in country to meet the needs of those seeking refuge and victims of modern slavery. 2, the amendment would require an assessment of the levels of protection and support, including risks of trafficking and re-trafficking and wider direct and indirect non-refoulement. 3, detailed consultation with national and international stakeholders will mean greater transparency for the implementation of this legislation and make sure it's put into place with appropriate structures around due diligence and accountability, given the significant implications for those seeking refuge and victims of modern slavery. And lastly, it would necessitate the government making clear how the duty in Section 2 of this bill and the powers in Section 3 does not contravene national or international legal instruments in the implementation of this bill, should it become law, and this includes those various international conventions that I've referred to earlier on, and which, because of the failure to be able to declare the compatibility of this bill with the European Convention on Human Rights, speaks into the remarks made earlier on today by the noble Lord, my noble friend Lord Hannay, about the reputational loss that there will be to this country if we are seen to be derelict in our upholding of conventions and treaties which have served us so well in the past. I beg to you.